So we have a major new development in one of the most important Second Amendment machine gun cases that is moving right now through the federal courts. The Brown machine gun case, which is currently pending in front of the Fifth Circuit, just took a major turn. The Trump DOJ has now filed new papers telling the Fifth Circuit that the case should be dismissed immediately based on some new precedent and also based on what the Supreme Court did in another case. So let's break down what is currently happening in this critical challenge. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. You can also click the like button. That just tells the algorithm that you appreciate this content, and so it shares it to more people. I also want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form's an amazing company. They support the Second Amendment, and also they have great supplements. But one of the things that we're going to do this month is that if you order any First Form supplements this month, you will be entered into kind of a giveaway. What I'm going to be doing is giving away some of my channel shirts, patches, and things like that to anyone that orders First Form supplements this month. Again, we'll pull that information and you'll be entered into this drawing, and it's just going to be completely random, and you'll get a shirt, patches, and things like that from me. And the plan is to kind of run this going forward for anyone that supports First Form in the mission and also them supporting the channel. So if you're interested in that, check them out using the link down below. And also, if you use that link and you order any supplements, you can also get a free 5-pack of protein sticks. So not only will you get those protein sticks, but you'll be also entered into this drawing. Now, as I mentioned in the intro, we are going to be discussing a critical machine gun ban challenge, which is currently pending in front of the Fifth Circuit, and that case is called U.S. versus Brown. This case challenges 18 U.S.C. Section 922(o), the federal law that bans the possession of machine guns manufactured after 1986. In this case, the defendant argued that the law here in question violates the Second Amendment under the Supreme Court's recent Bruin framework, and the district court on review of this case actually agreed with the individual. The district court judge ruled that the federal government failed to show that banning simple possession of machine guns is consistent with the nation's historical tradition of firearms regulations. The court also rejected the government's reliance on older Fifth Circuit precedent that had previously upheld machine gun bans, and that also happened prior to Bruin. The judge explained that Bruin fundamentally changed the legal framework for evaluating Second Amendment restrictions, and therefore he argued that that Fifth Circuit precedent was no longer good. He stated that under the new standard, the government carries the burden of proving historical support for these restrictions. And according to that court, the government failed to meet that burden. So the judge dismissed the machine gun possession charge against this individual. The court also addressed one of the federal government's most common arguments, which is that machine guns are supposedly dangerous and unusual weapons. The court pointed out that there were more than 740,000 legally registered machine guns in the United States, and the government offered no explanation for why a weapon possessed by hundreds of thousands of Americans would not qualify as being in common use. Because of that, the judge rejected the government's argument and ruled that the prosecution violated the Second Amendment. Now, naturally, because of that ruling, which struck down this charge against machine gun possession against this individual, the federal government decided to appeal that decision up to the Fifth Circuit. Currently, the Trump DOJ is asking for the Fifth Circuit to reverse that ruling, and their arguments are exactly what have been seen in other machine gun cases. The government claims that machine guns are dangerous and unusual weapons. They are not typically possessed for lawful self-defense purposes, and therefore they are not protected by the Second Amendment. They also argue that Bruin did not overrule earlier Fifth Circuit precedent, particularly a case which was called Hollis, which had previously upheld federal machine gun restrictions in the Fifth Circuit. So according to the Trump DOJ, the Fifth Circuit should simply rely on its prior precedent and reverse the district court ruling right here and now. But here's where things have kind of got a little bit more complicated based on what is now developed in the Supreme Court in some other cases. Recently, another major machine gun case reached the federal courts, and that case was called U.S. versus Morgan. In that case, a district court initially ruled that the federal machine gun restrictions were unconstitutional as applied to the defendant there, but the government decided to appeal up to the 10th Circuit. The 10th Circuit ultimately decided to reverse that lower court ruling. They sided with the Trump DOJ, and that then led that case to go up to the Supreme Court. The court ruled that the defendant failed to show that machine guns are commonly used by law-abiding citizens for lawful self-defense, and instead the court concluded that machine guns fall outside the protections of the Second Amendment. Again, after losing at the 10th Circuit level, the defendant decided to seek Supreme Court review. But the Supreme Court recently denied cert, so they denied review in this case, meaning that the Supreme Court declined to hear the case and it allowed the 10th Circuit ruling to stand and remain in place. And now the Trump DOJ is using that Morgan decision as a weapon in this Brown challenge. The federal government is now pointing to that Morgan ruling and another decision, which just recently happened in the 5th Circuit, arguing that it proves that the district court in the Brown case actually got this wrong. Even more aggressively, the Trump DOJ is arguing that the 5th Circuit should not even hold oral arguments in this case at all. Instead, they want the court to simply rely on the Morgan denial and the new precedent in the 5th Circuit to reverse the district court decision based solely on what was written in the briefs. So essentially, the government is saying the issue is already settled and the 5th Circuit should just shut this case down immediately. So where does this leave us in this case? Well, right now we have two competing views emerging in the courts. Some district courts have ruled that machine gun bans violate the Second Amendment, and they also do not comply with the Bruin standard that was outlined by the Supreme Court. But appellate courts like the 10th Circuit are pushing back and continuing to uphold these restrictions. Now the DOJ is trying to use the Morgan ruling in that decision as leverage to stop this Brown challenge before it even gains momentum, and they're also pointing to some 5th Circuit precedent to try to stop this case as well. If the 5th Circuit agrees with the federal government, this case would be dismissed quickly, but if the 5th Circuit rejects that DOJ argument and allows this case to proceed forward, this could become one of the most important Second Amendment cases in our country right now, because this is a direct challenge to the GCA and these whole machine gun ban restrictions and all the restrictions that are currently in place. And also, if the 5th Circuit rules in our favor, that would create a critical circuit split where the 5th Circuit says something different from the 10th Circuit, and that could intrigue the Supreme Court to finally want to address this issue. For now, the Brown case is still pending in the 5th Circuit, and the big question is whether the court will allow full arguments or follow the DOJ's request to shut this case down using that Morgan ruling. Either way, this is a major case to watch to see how this develops, if a circuit split also develops based on what the 5th Circuit says, and if this eventually will make its way to the Supreme Court as well, and potentially put pressure on them to have to address this issue. So as soon as we get more information, as this unravels more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of two-way content, and so it shares it to more people. Also, don't forget, if you want to enter the drawing to win the channel merch, you can do that using the links down below by ordering something from First Form. But as always, thank you so much for all of your support, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.